It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show. You know, I get a lot of questions sometimes, man. People be trying to figure me out like, 1 minute you rapping, the next you breaking down the industry on some executive guru shit. Are you a content creator, rapper, podcast host, part-time chef? Bro, what is it that you really do? I'm a rapper slash writer slash content creator. I'm the independent voice when it come to getting this paper. I'm an educator, news anchor, rule breaker, room shaker. Feeling by clean as a new taper. I'm the Daily Mail. I'm the rap game Dave Chappelle. Stay connected to the net like AOL. Sipping tea like wine in a holy grail. You don't like it, you know you go home, my genitalia. Man, I'm mad thing. Yeah, I'm mad thing. Shout it, man, I'm mad thing. Yeah, I'm mad thing. Shout it, man, I'm mad thing. Yeah, I'm mad thing. Shout it, whatever I wanna be. I gotta feel like I'm free, man, I'm mad thing. Yeah, I'm mad thing, shout it, man, I'm mad thing. Yeah, I'm mad thing, shout it, man, I'm mad thing. Yeah, I'm mad thing, shout it, whatever I wanna be. I gotta feel like I'm free, ayy. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well this evening. In this particular video, we're gonna be giving y'all some updates on the legal proceedings of Drake versus UMG. We've got a couple things to get through, okay? Because we have an update from Drake as it pertains to his legal petition in Bexar County in Texas against UMG. And we also have to get into this alleged settlement that Drake has reached with iHeartMedia, who were also included in the legal petition in Texas. And then we've also got an update from his federal case against UMG in New York. And we just were talking about that the other day. So I guess my estimation was not completely wrong that he was postponing his tour so that he could get back and speak with his legal team, his legal counsel, and submit some more legal paperwork to put pressure on UMG so that he could be available for anything that they need to do. I don't think I was wrong about that, but I guess he also made time to go be at that WWE match in the meantime. Looks like he's involved in his own proverbial WWE match against UMG, though. And all of this, of course, by the way, is surrounded by Kendrick Lamar, Not Like Us, alleged payola, alleged incentives given to streaming platforms, etc., to boost the record or to promote it more than anything else for benefits. That's what Drake claims, right? So let's go ahead and open this up with his latest filing against UMG in Bexar County, Texas, to see what it is that he's got here that he's requesting or looking for at this current phase, because I think he wants to take this into the discovery phase, if I'm not mistaken, which he's also asking for in federal court. All right. So Aubrey Drake Graham, petitioner, requesting depositions of iHeartMedia and UMG recordings. All right. Petitioner's motion for discovery under the Texas Citizens Participation Act and motion for continuance of TCPA hearing. Introduction and factual background here. Petitioner Aubrey Drake Graham files this motion seeking limited discovery from UMG pursuant to Civil Practice and Remedies Code 27006B and would show as follows. Drake filed a petition under Texas Rule of Civil Procedure 202 seeking narrow pre-suit discovery into the conduct of UMG and iHeartMedia Inc. in connection with UMG's unlawful efforts to turn the song Not Like Us into a viral mega hit. So as you can see in the first sentence of the factual history, they're throwing Not Like Us right into the mix. So anybody that tries to tell y'all Kendrick Lamar, and I think I've even said this myself, that Kendrick Lamar is not affected by this, although he's not a defendant, he doesn't have to submit anything into discovery. He's not necessarily being brought up for questioning at this moment. All of this is centered around Kendrick Lamar. He's doing everything in his power to dig into the validity of Kendrick Lamar and the success of this record without having to directly sue him. It's completely bitch made, but whatever. So they say, example A, UMG holds exclusive control over licensing the song, and as the petition alleges, engaged in deliberate, irregular, and inappropriate business practices, including covert and illegal pay-to-play deals, to create a record-shattering spread of Not Like Us. Drake's concerns regarding UMG's apparent misconduct are detailed in his petition, but also supported by widespread concerns regarding industry practices, including in Texas. Recently, on February 6, 2025, the Federal Communications Commission, the FCC, issued an enforcement advisory regarding the covert manipulation of radio airplay in violation of FCC's Payola rules. Now, we're going to get into what the FCC is looking into regarding iHeartMedia. I don't believe that it's directly involved with songs per se, or like a Not Like Us type of situation, especially since I don't believe Kendrick Lamar has performed at like Jingle Ball or anything like that. But I'll get into that because I think it really the FCC is probing iHeartMedia in terms of payola as it pertains to artists that receive invitations to perform at iHeartMedia events, live shows. But nonetheless, they are looking into them for some form of payola. So I will give him credence on that part, but it is a manipulation of wording, just as they're making reference to a covert manipulation of radio airplay. Got to be honest. Okay? In violation of FCC's payola rules. Just last week, on February 24th, the FCC made clear that its regulatory interests touch on conduct in the district. Indeed, the FCC made a public request. It's sent to iHeartMedia regarding compliance with payola rules in connection with upcoming events in Texas. Along these lines, Drake's petition sought pre-suit discovery because he believes UMG's improper promotional conduct vis-a-vis the Not Like Us song may give rise to claims of civil fraud, racketeering, or other causes of action against UMG and its many as of yet unidentified co-conspirators. So they're saying many as of yet unidentified co-conspirators. So Drake is looking into the entire industry of radio to see where they may have been committing some sort of fraud, racketeering, or, of course, he also filed defamation to say that all of these companies have conspired against him in order to make this song much bigger. Determined to resist discovery, however limited, into its secret promotional tactics at all costs, on January 23rd, UMG filed a motion to dismiss Drake's petition under the Texas Participation Act, arguing that Drake's petition is foreclosed by the TCPA because inter alia, the petition is allegedly related to UMG's core free speech protected by the First Amendment, and because the commercial speech exception of the TCPA, which exempts certain types of commercial conduct from the TCPA regime, does not apply. Because remember, Drake was looking into him being called a PDF on the record. He was looking into being whopped. He was looking into, getting hands-on and being polished and all of those different things. And UMG says, hey, all of this is free speech from Kendrick Lamar. You engaged in a rap battle, and as a result, these things were said on record. We received both records from you and Kendrick Lamar. We released records from both you and Kendrick Lamar. Therefore, both of y'all are covered under free speech. So what is the problem, right? That's pretty much UMG's response. They continue, Drake will respond to the merits of this TCPA motion in due course. However, under the clear language of the TCPA and reinforced by the case law, Drake is entitled to discovery on UMG's sweeping assertions made in the TCPA motion. Specifically, Section 27006B provides for limited discovery relevant to a motion to dismiss under the TCPA. This provision acts as a critical check against defendants using the TCPA as a blunt instrument to snuff out meritorious suits. That is exactly what UMG is trying to do here. Thus, Drake respectfully moves the court for permission to take a corporate representative deposition not to exceed 4 hours and the production of limited categories of documents that go to the factual basis of UMG's TCPA related claims. So they want about 4 hours of UMG's time, and they want to produce some paperwork to just see what's going on. Without this discovery, Drake cannot fairly test or refute the factual basis for UMG's claims that, for example, it was acting merely as a clearinghouse in promoting the song, or that it was not doing so in its capacity as a seller of goods or services. Finally, because Drake is entitled to pre-hearing discovery under Section 27006B, Drake requests a continuance of the hearing on the TCPA motion currently set for March 24th, 2024 to afford a reasonable amount of time to complete discovery. Okay? They said the TCPA is not a tool always ready to obtain the early dismissal of every objectionable case or controversy. Instead, the TCPA exists both to protect the rights of plaintiffs with meritorious lawsuits as well as to safeguard freedom of speech. To ensure meritorious lawsuits are not dismissed, the TCPA explicitly authorizes discovery prior to a hearing on a TCPA motion to dismiss. Okay? We're going to go past some of this because I know it's very repetitive. They say Drake has good cause to seek limited discovery relevant to the TCPA motion, in particular because the factual information necessary to conclusively refute the factual basis of several of UMG's claims is in UMG's sole possession. So basically, in order for them to come up with some level of fraud or civil conspiracy, they need to look into the books of UMG. At this current point, UMG is saying, fuck you, you're not getting access to our books unless the courts deem it necessary to get into our books. Not because we're hiding anything necessarily. I can't say they have nothing to hide, but that's their position. We're not hiding anything. We're just not giving you access to our books without the courts ordering it, right? And to be honest, if Drake can look into the books of UMG for an artist not named Drake, that is a problem. Because now if you start looking into Not Like Us and you look into the promotion campaign and the advertising dollars and all of these different things, and he gets access to see what is being spent to promote another artist, is Kendrick Lamar going to get the opportunity to look into Drake the same way for his whatever song, right? Because if what's good for the goose got to be good for the gander, right? But Drake is trying to take this legal, right? He has no proof of anything. He can only say what he suspects and what he believes. But he's saying, I need the court's permission to set this hearing up and to make them submit these documents for discovery so that we can see every dollar that was spent on Not Like Us, where that dollar went, who received it, and what the incentive was attached to said money spent to advertise this song, so that we can try to find some type of wrongdoing to understand why this song is so fucking big. Why is this song so fucking, why won't it go away? Right? Not to mention the fact that he was against this song being aired from the jump. Within 2 weeks of the song being out, he was already filing paperwork saying, nah, dog, this shit gotta go. Y'all should not even be allowing him to put this out. It's defaming me. I'm losing money, which is all false. Only thing Drake has lost since the battle with Kendrick Lamar is his good standing with the fans. And that's what happens in any rap battle. If you lose standing with the fans. Go ask J. Cole. He backed out. He lost standing with the fans. They sitting on the same bench, right? I don't even count that fucking Nike shoe because nobody was gonna buy that shit anyway. That was you trying to re-release some Tim Hardaways, nigga. Fuck your shoe. So no. Now let's continue. They say the TCPA motion makes several arguments which can be disproven with limited factual discovery. First, UMG asserts that its conduct in promoting Not Like Us is a protected communication under the First Amendment of the TCPA. TCPA motion at 10 through 12. This argument relies on the factual predicate that the covert, i.e. not disclosed in public, promotional activities in which UMG engaged in order to distribute and encourage the publication of Not Like Us in Texas constitute core free speech. And let's be clear here. Money spent in promotional activities are not labeled covert. You don't have to tell the public that you're promoting a song. Otherwise, every song that we see being promoted on social media by an artist, by a label, by a management house, by a talent agency or some shit, they would all have labels that say sponsored. That's not always the case. You don't have to disclose that, oh, we paid for this promotion. Now, if you pay a content creator to advertise some shit, you're supposed to say paid promotion or something like that, or show the collaboration or whatever. There's a protocol for that. But that's not the only type of promotion that took place. Anyway, we'll continue. Extended First Amendment protections to a content promoter. So that's some old shit that they're referencing here. Whether UMG's secret activities, again, they keep saying secret activities. We're going to find out the secret activities they've been doing for your ass. You keep playing. And we're going to find out your whole career was a fraud. But keep digging if you want to. Whether UMG's secret activities with private companies in Texas to promote a song over which UMG was and is the exclusive license holder makes it remotely analogous to the kind of clearinghouse described in Cinevision is a factual issue clearly relevant to the TCPA motion, and therefore Drake is entitled to limited discovery and connections therewith. Excuse me. UMG, not Drake, possesses all of the relevant factual information that would enable Drake to rebut UMG's assertion. Well, they're the company. You're just an artist. You're just an artist. Why would you even think you're supposed to have this information? For example, Drake does not know the term, scope, or purpose of any agreements or arrangements UMG may have had with iHeartMedia or others in this district for that matter, and whether those agreements place UMG in the same position that Cinevision occupied vis-a-vis its counterparty of a clearinghouse. Furthermore, the essence of the legal claims Drake seeks to assert against UMG is not that UMG merely promoted Not Like Us, as Cinevision did, but that it used prohibited, improper, and or misleading means, which of course could not possibly receive First Amendment protection to do so. So he's saying they had to do something illegal. Discovery is therefore essential to be able to determine whether the application of the TCPA is appropriate in the first instance. Such information, whether in the form of documents or deposition testimony, is the best evidence of the precise nature of UMG's conduct, and UMG should not be permitted to escape discovery under Section 202 and to pursue fee shifting under the TCPA based on nothing other than its own conclusory statements of the nature of his conduct that assume answers to the precise questions on which Drake has sought discovery. Second, UMG argues that the conduct at issue in the petition does not fall into the TCPA's exception for commercial speech. Okay, the commercial speech exemption applies where the defendant was primarily engaged in the business of selling or leasing goods. The defendant made the statement or engaged in the conduct on which the claim is based in the defendant's capacity as a seller or lesser of the goods or services. The statement or conduct at an issue arose out of a commercial transaction involving the kinds of goods and services the defendant provides, and the intended audience of the statement or conduct were actual or potential customers of the defendant for the kind of goods or services the defendant provides. They say here, it is likely that the commercial speech exception would cover the conduct and statements UMG made to iHeart and others in connection with licensing the song. Indeed, on their face, the ways in which UMG covertly promoted Not Like Us to radio stations and online streaming services, i.e. an organization engaged in the businesses of selling music, paying radio stations to play music, appear to be textbook commercial speech. But absent discovery, Drake would be forced to rely upon UMG's conclusory and self-serving statements rather than actual facts in determining the exception's applicability. So here, Drake's lawyers say, you're probably telling the truth. However, we're not just going to rely on what you're saying. We want to look into the paperwork. We need discovery. Even if you are telling the truth, we want you to prove it rather than take your word for it, right? They say, thankfully, the TCPA does not permit UMG to impose liability on Drake based solely on its say-so. Drake is entitled to discovery into whether, for example, UMG was acting as a seller when it was engaged in the promotional activities that formed the basis for the petition. Drake is also entitled to discovery into whether UMG's conduct in covertly promoting. I don't like that they keep saying covertly promoting. Their job as a record label company is to promote, so they don't got to covertly do shit. Arose out of a commercial transaction involving the sale of music, or whether the intended audience of the covert conduct was music consumers. Just as with the applicability of core free speech protections, whether UMG's conduct satisfies the commercial exception is best determined not by UMG's conclusory trust attestations, but by actual evidence. Once again, they say, we hear what you're saying, just give us the paperwork. Third, UMG argues that Drake cannot overcome the TCPA challenge because Drake filed it in an improper venue, TCPA MOT at 1820. As an initial matter, Drake disagrees with UMG's interpretation of Rule 202's residency requirements and will raise those substantive objections in his opposition to the TCPA motion. But putting that aside, Drake can separately defeat UMG's arguments as to venue if this court can establish personal jurisdiction over UMG either through substantial ties or through waiver of that objection. Drake seeks only narrow pre-hearing discovery as expressly permitted. Okay? Drake's TCPA discovery requests fall squarely in line with this pattern. So here are their requests. They would like a deposition of UMG via corporate representative, which shall last no longer than 4 hours and be on the following topics. UMG's private promotion strategy for Not Like Us. That's crazy. How you gonna try to dig into my promotional strategy for my song just because my shit outsold yours? That's crazy. To determine whether such communications are core free speech and or commercial speech, including but not limited to 1. Any agreement UMG had with iHeartRadio and or its radio stations. 2. Agreements UMG had with streaming services and other radio stations in the state of Texas. They've already showed y'all they don't got no shit going on with iHeartRadio. Y'all already have shown they didn't pay Spotify that extra benefit that you claimed, but whatever. 3, promotional agreements with influencers and other third parties in the state of Texas. I would love to see the influencers who have been allegedly paid or offered an agreement. Methods for tracking and boosting engagement on social media sites, such as using bots in the state of Texas, and the intended audience of the promotional activity, especially as it pertains to the state of Texas. How many high-profile influencers do y'all even have in Texas that UMG would personally want to create an agreement with to pay them to promote a song? Not saying that Texas doesn't have its fair share of influencers, but how many would be on their radar that could substantially promote a song in such a way that Not Like Us has been promoted? They also want to see UMG's commercial ties to and business relationships within the state of Texas, and see how often UMG employees travel to Texas on UMG related business and whether any UMG employees reside in Texas. Because again, as this pertains to a Texas filing, they can only review jurisdiction in the state. This is not a federal thing. Drake's other filing in New York, is federal. And probably, although I believe both filings don't have merit, I think the New York one, as it is federal, probably would be stronger, because if you're just looking into Texas, I don't think you're going to find too much. They want production of the following documents: records sufficient to show UMG's promotion strategy, Did I not just go through this shit? Um, Whether such communications are core free speech or commercial, including but not limited, any agreements UMG had with iHeartRadio and its radio stations, agreements UMG had with streaming services in the state of Texas, promotional agreements with influencers, other third parties, methods for tracking and boosting engagement on social media, such as by using bots, and the intended audience of the promotional activities in the state of Texas. Records sufficient to show the number of contracts UMG has with companies and or individuals located in the state of Texas, which all of these things I don't believe are necessarily illegal. They just want to know, who are y'all doing business with in the state of Texas? And we want to review the nature of that business relationship to ensure that you're not giving them some sort of incentives to blow this song up. Crazy. A list of all meetings held in Texas since January 1st, 2024, at which UMG personnel were present at, and at which Drake, Kendrick Lamar, or Not Like Us were discussed. So they want to review all mentions of Drake, Kendrick Lamar, or Not Like Us as it pertains to the state of Texas and UMG. Records of all financial transactions between UMG and companies and or individuals located in the state of Texas. Records sufficient to show revenues gained by UMG directly or indirectly related to the licensing and promotion of Not Like Us. They want to know how much money this nigga brought in the state of Texas off this song. Come on, dog. Records sufficient to show the revenue earned by UMG from the distribution, playing, licensing, or any other music, or other use of any music on. Oh my God. They want to know how much money UMG has made in the state of Texas, period. Not just from Not Like Us. They want all the music from January 1st, 2024 to now. How much money y'all making in Texas off all of my contemporaries on the label? Taylor Swift, Nicki Minaj, Kendrick, The Weeknd, all these motherfuckers are under UMG, whether they're on Republic, whether they're on Interscope. He wants to see the records. This nigga tripping. UMG noticed its TCPA motion for a hearing on March 24th, 2025. Drake therefore asked the court to continue the hearing on that motion pursuant to Texas civil practice, blah, 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 at 27004C until discovery can be completed. The discovery described above will be completed in enough time to allow the court to conduct a hearing on or before the 120-day deadline conclusion. For the above reasons, Drake respectfully asked this court to grant his request for the pre-hearing discovery and continue the hearing for the TCPA motion, which again is on March 24th of this year. Just a couple weeks. Okay? What else is in here? So this here is Aubrey Drake Graham's verified petition for Rule 202 depositions. Respondent UMG is one of a handful of companies that dominate the multi-billion-dollar music industry when it comes to the release of new music by its most prominent artists. UMG is meticulous in its planning and execution of the music it releases, promotes, and backs with its considerable financial resources. Yeah, this is the very company that gave you, allegedly, $500 million contract. I guess that wasn't enough. Not enough, huh? That is true, not just because of the amount of money on the line for UMG and its shareholders, but also because UMG's executives are eligible to receive incentive bonuses based on the revenue generated by their respective decisions, just like people in upper management at all companies. Bonuses are not illegal. Earlier this year, one of the artists that UMG has under contract presented UMG with a new song called Not Like Us. Before it approved the release of the song, UMG knew that the song itself, as well as its accompanying album art and music video, attacked the character of another one of UMG's most prominent artists, Drake, by falsely accusing him of being an SO offender, engaging in PDF acts, harboring S offenders, which is true, and committing other criminals as acts. Specifically, the song calls Drake a certified PDF, a predator, and someone whose name should be registered and placed on Neighborhood Watch. Pursuant to its rights under various contracts, UMG has exclusive control over the licensing of Not Like Us and could have refused to release or distribute the song or required the offending material to be edited and or removed, just like they could and probably should have done for Push-Ups and Family Matters, but they didn't. So what is you bitching about? But UMG chose to do the opposite. Oh, let's not forget the hard part dicks. Excuse me. Yeah. Yeah, the hard part dicks. Cause we ain't gonna call it 6. Where you botched this man's musical discoveries all through the shit, trying to claim that he was S8 as a child, and you were completely misquoting the music. But I guess UMG should have let you release your songs dissing him, making claims into his family, his children, his lady, but he shouldn't be able to respond back. Got it. UMG designed, financed, and then they executed a plan to turn Not Like Us into a viral mega hit with the intent of using the spectacle of harm to Drake and his business to drive consumer hysteria and, of course, massive revenues. That plan succeeded, likely beyond UMG's wildest expectations. So were you not trying to drive consumer hysteria when you called him a woman beater? Right? Mr. I want to see what Whitney need. Do you hit her because she bigger than you? Hands on your knees, shake that ass, bitch. You calling his woman a bitch? That wasn't trying to drive consumer hysteria, and in no way. What about the unauthorized AI usage of Tupac, in which his estate had to say, take that shit down? That wasn't attempting to cause consumer hysteria? UMG released the song Not Like Us on May 4th. In its music video on July 4th, 2024, UMG relied on its exclusive licensing rights and in coordination with known and unknown third parties utilized every tool in its arsenal to spread Not Like Us. You just mad because it was a radio-friendly record in terms of production and style, while you were releasing records with no hooks. UMG made Not Like Us available for radio play, including to iHeartMedia, a mass media corporation headquartered in San Antonio. iHeartMedia boasts that it is the #1 audio media company in the U.S. based on consumer reach. iHeart claims that it reaches 9 out of 10 Americans every month and has more reach than any other media company in the U.S. Radio stations all over the country, including stations owned by iHeartMedia, have played Not Like Us, just like they've played Family Matters, but it's just not as marketable of a song. UMG and iHeartMedia have a long-standing symbiotic business relationship whereby iHeartMedia pays UMG to license and collect royalties for UMG artist songs over radio airplay and streaming services. As demonstrated by iHeartMedia's bankruptcy filings in 2018, the amount of money exchanged between iHeartMedia and UMG is substantial. In the last quarter of 2023, UMG, through its recorded music and music publishing divisions, had an ownership interest in more than 60% of the 100 songs listed in the Billboard Hot 100 radio charts, in which your name was in the mix, if we're going back to 2023. That's when For All the Dogs was still in rotation. Rich Baby Daddy, slime you out? Okay. Without its business deals with UMG, iHeartMedia would lose access to a majority of its top radio hits. On the first week of its release, Not Like Us ranked first on Billboard's Hot 100 with 5 million radio airplay audience impressions. In the week that the Not Like Us music video was released, Not Like Us played on the radio an additional 40 million times. 4 months later, the iHeartRadio leaderboard reported that Not Like Us was among the top 2 songs with the most plays on iHeartRadio stations and explained in a newsletter that it had been heard more than 25 million times across iHeartRadio's platforms alone. As of the date of this filing, the iHeartRadio leaderboard still reports Not Like Us as among the most widely played songs on iHeartRadio stations. Billboard reported that as of October 7, 2024, Not Like Us reached 45.4 million in total audience impressions on radio, with 15 non-consecutive weeks in charge of the R&B hip-hop airplay list. It's a fucking hit. Tell them why you mad. Radio was only one of the mediums on which UMG relied to spread Not Like Us. Within a week of its initial release, Not Like Us broke the record for the most streamed song in a 7-day period with 96 million streams. On October 7, 2024, Not Like Us broke the record for the most weeks, 21, at number 1 on Billboard's Hot Rap Songs based on streaming sales and radio play. Since its initial release, Not Like Us has been seen and heard billions of times. The record-shattering spread of Not Like Us on streaming sales and radio play was deliberate, and it appears to have relied upon irregular and inappropriate business practices. So you're saying that just the general interest in this song, because little kids love this fucking song, is not organic, it's abnormal. Coming from the guy who typically broke all the records. But nobody looked into how abnormal that was. According to one inside source known to Petitioner, UMG made covert payments to a number of platforms, including radio stations, to play and promote Not Like Us without disclosing those payments to listeners. This practice, known as Payola, is prohibited by the Communications Act of 1934 and has been subject of regulatory scrutiny. In 2006, UMG agreed to pay $12 million in a settlement with the New York Attorney General. I don't give a fuck what happened in 2006. This is before you or Kendrick was under the umbrella. Petitioner has learned of at least one UMG employee making payments to an independent radio promoter who had agreed to transfer those payments to certain radio stations and or radio station employees. These radio stations subsequently played Not Like Us, and to Petitioner's knowledge, did so without disclosing to their listeners that they had been paid by UMG to do so. Independent radio promoters are also not illegal. But if you want to go by the DJ That Don't Spin's assertion, he claims that Drake doesn't employ independent radio promotions for his songs and never has. That's what the DJ That Don't Spin says. Petitioner has been unable to confirm whether any iHeartRadio stations were among the stations paid as part of UMG's pay-to-play scheme, or whether there were any direct payments from UMG to iHeartRadio to promote Not Like Us. Given iHeartMedia's status as the number 1 audio company in the country, Petitioner believes that UMG engaged in similar tactics to drive radio play of Not Like Us on iHeartMedia stations. UMG also directed its digital marketing team to use discretionary funds provided or reimbursed by UMG to pay unknown third parties to share the Not Like Us song and video in the days after they were released. The purpose of UMG's payments to third parties was to inflate artificially the metrics reported relating to Not Like Us, to encourage media and music critic commentary, and ultimately to make it go viral. But they just did the investigation into bots, and Not Like Us and Kendrick Lamar as a whole underwent no adjustments. One whistleblower, whose identity is unknown, revealed publicly that someone from management, y'all still using this DJ That Don't Spin whistleblower theory when this motherfucker already admitted he lied. This shit out my face. Petitioner has received information that UMG also paid certain third-party influencers to promote Not Like Us. Nope, get that shit out my face. They didn't pay them niggas. All they did was lift UMG copyright restriction. That is not money from UMG. Fuck out my face. That's not payola. You release songs on your fucking Instagram page that don't get copyright claimed unless people don't like it. Then you want to come and strike niggas' pages. But otherwise, you be doing the same shit. Get this shit out my face. Petitioner brings this action for a discrete and specific purpose: to understand whether and how UMG funneled payments to iHeartRadio and its radio stations as a part of a pay-to-play scheme. Petitioner has amassed sufficient facts, we would love to see them, to pursue certain tortious claims against UMG, including but not limited to a claim for defamation, but currently lacks factual support necessary to determine whether he may bring claims of civil fraud and racketeering against UMG and its many as of yet unidentified co-conspirators who violated Payola laws and accepted illicit payments and other things of value from UMG without disclosure. So he's standing on his square. He wants them to be deposed so that they have to answer uncomfortable questions. We'll see how this goes from there. Petitioner respectfully requests that the court issue an order setting a date for hearing on this petition with at least 15 days notice, and after that hearing, issue an order requiring iHeartMedia's corporate representative to testify by oral deposition related to the matters described herein. So they still want iHeartMedia to be questioned. They want UMG's corporate representative to testify by oral deposition, and they want all other relief at law or in inequity to which petitioner may be shown to be justly entitled. Now, as it pertains to Drake and his federal situation with UMG, UMG was trying to avoid a pretrial conference, right? Because they're trying to write their motion for dismissal, and they felt like they needed more time and that they should be able to submit their motion for dismissal before having to attend any pretrial conference. The judge here has said, no, y'all need to make this meeting happen, all right? So Jeanette A. Vargas, United States District Judge, says defendants' request to adjourn the initial pretrial conference scheduled for April 2nd, 2025 is denied, which means that UMG will have to show up. It is not the practice of this court to routinely stay discovery pending the outcome of a motion to dismiss. A party seeking a stay of discovery shall file a letter motion pursuant to this court's individual rules and practices in civil cases. Any such letter motion will be discussed at the April 2nd conference. The clerk of court is respectfully directed to terminate their request. Okay? So somebody from UMG is going to have to at least come and be a part of this conference April 2nd. It's about a month from now. So we'll see how that goes. Right? Now, as Drake mentioned in his petition in Texas, he claims that iHeartRadio is being investigated for other acts of payola. So let's get to what that's about. So here's an article via Variety where they say the FCC probes iHeartMedia following accusations of payola law violations. Okay? The Federal Communications Commission, aka the FCC, has warned radio station owners that it is cracking down on what it describes as payola practices. In a letter sent Monday to iHeartMedia CEO Robert Pittman, FCC Chairman Brandon Carr says the FCC is scrutinizing the company's activity, particularly around the live music events it hosts throughout the year. So this isn't necessarily about airplay specifically. They say specifically, the FCC is pressing iHeart on whether it improperly pressures artists to perform without payment at events such as the upcoming iHeart Country Music Festival on May 3rd in Austin, Texas. Okay? They say it would be particularly concerning to me if on the heels of the FCC's enforcement advisory, iHeart is proceeding in a manner that does not comply with federal payola requirements. Indeed, I want to know whether iHeart is effectively and secretly forcing musicians to choose between 1, receiving their usual, ordinary, and full-scale compensation for performing, or 2, receiving less favorable airplay on iHeart radio stations. So what this is basically backing artists into a corner saying, hey, we want you to perform at the iHeart Music Country Music Festival, or we want you to perform at Jingle Ball, or we want you to perform at any of their other radio station live events that are so big, right? And the artist says, I'm good, right? And they say, if I do show up, I want to be paid. And they say, hey, we don't pay you motherfuckers to perform. But what we can do is get you some more time on the box, baby. You want some more time on the box? You come perform, give us a 30-minute set, come do your shit, and you taken care of. We gonna get you, hey, you want you a top 10 hit, top 20, 30 hit, don't you? Come fuck with me. That's what they're claiming could be happening. But again, as it pertains to Kendrick Lamar, this nigga hasn't performed nowhere that has not been commissioned by his own team and setup. Right? So that removes him from this anyway. Carr references the FCC's February 6 issued advisory that followed payola accusations or forced quid pro quo, leveled by Senator Marsha Blackburn, reminding radio broadcasters that manipulating airplay based on artist participation in station events without proper disclosure violates federal laws. This upcoming iHeart event provides the commission with a real-world example of how such events are put together, including artist solicitation and compensation. This year's iHeart Country Festival is slated to feature Brooks, I guess Garth Brooks, and Dunn, Thomas Rhett, Rascal Flatts, Sam Hunt, Megan Moroney, Bailey Zimmerman, and Nate Smith. In a statement shared with Variety, iHeart representatives said they appreciate FCC Chairman Carr's interest in ensuring the radio industry is compliant with all applicable laws and regulations, and confirmed they would be responding expeditiously to the questions posed by Carr. The FCC is requesting information with a deadline of 10 days from iHeart regarding the artists scheduled to appear, any compensation or otherwise they're receiving, and typical performance fees for the musicians outside of the festival, right? So they're saying, you need to show me how you contacted these artists, what you're paying these artists, and what you're paying these artists compared to what they typically would receive, so that we can try to see any differences, any disparities, and try to make sure that y'all are not leveraging y'all position as a powerful radio company, making artists come perform at y'all shit, or else, if they don't, you're threatening that you won't play them on the stations. None of this has been proven. They're just asking for verification of how this goes. Now, who put the allegations out against them? I don't know in this particular instance. This ain't Drake. Okay? The company must also disclose whether artist participation at the event will influence their airplay. Additional requests from the FCC include iHeart providing a list of any musicians, artists, or acts that were invited to appear or perform at the festival but declined to do so. To the extent you have such information, please indicate why they declined to appear. We look forward to demonstrating to the commission how performing at the iHeart Country Festival or declining to do so has no bearing on our radio station's airplay. iHeart statement continues. So they're saying, hey, we're going to give you all the information you need, and y'all going to see that this is above board. Now, if you think this is an anomaly, they say Carr has also ordered an investigation into NPR and PBS over possible violations of government rules, namely by highlighting their acknowledgement of financial sponsors on the air. So this seems to be a pretty widespread thing where the FCC is just looking into the practices of the radio industry at this current point, probably because they need updates to see how everything is being done, just to ensure that everything is above board as stated. But again, these investigations don't necessarily coincide with the investigation that Drake is looking into as far as Not Like Us, The Spins, because again, Kendrick has not performed at any of their shit anyway. So by that assertion, his unwillingness to perform at any of their festivals should impact his airplay negatively. If we're going by the claims in this article. But as Drake so eloquently and his team displayed to us, he's had nothing but success on iHeartRadio, despite not showing up for any of their events. So that goes to show you he shouldn't even be named in the same sentence as this particular investigation, but his team, as in Drake, put them together anyway. Lauren LaRosa, aka Brown Girl Grinding from the Breakfast Club, she's issued a statement. She spoke to iHeart as well about Drake's allegations and whatever supposed settlement that was supposedly reached. She says there are reports that Drake dropped iHeart from his legal petition in Texas over Not Like Us because of a private settlement. But here's what actually happened. Via iHeart's official statement, Drake dropped iHeart from their suit after we agreed to provide them emails showing that we were not engaged in any of the actions we were accused of. Okay? So they've issued a statement via her stating, we showed emails to let Drake know we have not actually engaged in any payola, any improper communications with UMG. So please remove us. Now, iHeart is no longer a defendant in his petition, but they're still asking to be deposed and provide further information about Not Like Us. And of course, UMG is being asked to provide all information regarding Not Like Us in the state of Texas radio, and they have to provide all information regarding all UMG artists in the state of Texas to ensure that they're not being botted or improperly promoted, illegally promoted, right? Don't think this is going to end the way that Drake believes or is aiming for, but I guess he just has to see it for himself. Now, I know this was a lot to get through and sit through. I'm sure some people have left the conversation because, getting into the weeds of all this stuff is not necessarily sexy, but I feel like it's my responsibility on my platform. The show is called Inside the Industry. We don't do no fake dives. You know what I'm saying? We got to do the deep dives. We got to get into the real shit, especially if it's available to the public. Let's talk about what's really there. Let's get into the paperwork. Let's get into the requests and accurately report on this thing, right? I'm not a salacious channel. I could have summarized that and just been like, this nigga's a fucking fool, which I believe. But I want to give y'all accurate information, as accurate as I can possibly produce, so that when all of this stuff comes to a head, and it will at some point, there will be either a dismissal or perhaps an admission of guilt from UMG if it comes to that. And I want to go ahead and just document this properly along the way so that when people look back at this content at a later time, they're being met with accurate information rather than a bunch of salacious lies and BS that I feel like a lot of people are using just to leverage and build their platforms. But what you going to stand on with that platform? Let me know what y'all think of all this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. I'll catch y'all on the next one, man. Much love and respect, y'all. Peace. King of my city and cul-de-sac. Coming out swinging like soldier rag. Leading my people like quarterback. Boy, I study this shit, I'm an almanac. Had to get up and grind. Knowledge is booming, I'm here to apply. Came with the chip and the dip, it just single the mind. We finna do more than survive. I need my check. Spinning the block for the Gouda. We hitting the jeweler to flood out the net. We don't do beef for computers, I'm straight out the sewer. We come when you rest. Niggas be looking perplexed, so keeping my foot on their neck. No map, I trust my gut for the quest. With drama, I'm fully abreast. I was ready for years and they doubted me. All of a sudden they tell me they proud of me. I've been dropping these haters like calories. Cross them out, I came back with some boundaries. Stand for my honor, but too raw, no corner. Packing the stick with a drummer. Wanna catch my bad, won't fumble. I done came too far to be humble.